Hello, this is Robert Perkins, the immigration professor, and I am here today to talk to you about de-stressing deportation. This is part 2 in a 4-part series, and in this part we're going to be talking about cancellation of removal for people that do not have status, do not have a green card, they've been here a while, they're facing deportation. This is one way that they could actually not only defend themselves against deportation, but that it could also become a green card holder in the United States. So it's kind of nice. My videos are all available about deportation and other topics on my website. My name again is Robert Perkins. My website is www.immigration-professor.com. You could also call our offices about your specific case. We have offices in California and Illinois. The California number is 310-384-0200, and the rest of the offices are all on our website, immigration-professor.com. So let's talk a little bit about cancellation of removal. Again, another way we can de-stress the deportation process. And there's 3 basic elements to cancellation of removal. The first element is 10 years of continuous residence. That is the first element. So whoever, if you're facing deportation, go around this way, and you've been here 10 years continuously, you may be eligible for cancellation of removal. Now, however, just being here 10 years in and of itself does not make you eligible for cancellation of removal. Some people call my office and they say, oh, I've been here 10 years, can I stay? That is not the case. The second element of this is good moral character. So you have to show good moral character. And what that means is that you haven't been convicted of a serious crime. And I can't get into too much details about that in a short video, but if you are trying to get cancellation and you have some kind of criminal conviction, you'd have to contact us and go through sort of an individual analysis of your case. And the third element, which actually is the most important, is you have to have extreme and unusual hardship to a U.S. citizen or lawful permanent resident, which means green card, spouse, husband or wife, that means, parent, or child. So you not only have to have the 10 years and not have a serious crime, but you have to have a relative in the United States, and a fairly immediate relative at that, that has some kind of immigration status, either a citizen or a permanent resident. So, and you have to show some kind of hardship to that person. Again, more information about cancellation of removal you can find on my website, www.immigration-professor.com, or you can call us at 310-384-0200. So let's talk a little bit more about a couple of the elements of cancellation of removal and proving your case. 10 years of continuous residence, what does that mean? Well, you have to show that you are physically here for 10 years. It doesn't matter how you entered, if you entered illegally or if you entered on some kind of visa. You have to show you're here all the time continuously. Things like tax returns are helpful to show that you were here if you pay taxes. Receipts, pictures of you here in the United States, if somehow they can be dated. Affidavits from other people, school records, anything that you might have to show that you've been here for 10 years. Also, one thing that's important is sometimes we have cases of people that are taking trips in and out of the United States. If they are gone for more than 90 days in a single trip, that breaks their continuous residence. The other thing that breaks their continuous residence is when they are actually placed in deportation proceedings, or removal proceedings as they're now called. So let's say somebody came here 9.5 years ago, and then the government finds them and they want to remove or deport them, and they want to claim cancellation of removal. Their 10 years is cut off from the time they are served with papers putting them in proceedings. Now, there's some argument that there may be some give in that, but generally that's the case. So that's an important thing to know about that element. And as we mentioned, the good moral character element, the 10 years kind of relates to it in a way because certain crimes will cut off the 10 years of continuous residence for purposes of cancellation of removal. Where people really win or lose their case is showing extreme and unusual hardship to their U.S. citizen or permanent resident, spouse, parent, or child. That's the hardest part of most cancellation of removal cases. So I'm going to spend the last part of the video talking about that. I will say, just to kind of relate this to my first video, that even if you don't have a great case of extreme and unusual hardship, you still have the right to present your case in court and take all your appeals, as I've talked about in my first video. So what does it mean, extreme and unusual hardship? Well, let's talk a little bit about what that might mean to the spouse, parent, or child. What are the things that the court will consider in your case? The first and foremost are medical hardship. That always is a big one with most judges. And typically, for the classic example is, let's say you have a parent in the United States that you are taking care of that's dying of cancer, and they don't have any money, and the only place they can get their treatment is in the United States. Medical hardship would be something to that relative, or it could be to the child or to the spouse. Psychological hardship is important. So, for example, obviously losing a relative can be painful psychologically, but what if that relative has already experienced some losses? What if that relative was the victim of molestation or rape or something else, and then all of a sudden they're about to lose their husband? That's another factor in hardship. Another one is financial. Who is making the money of the family? If the immigrant is the person that's making the money, then obviously if they're gone, their relative is going to experience some amount of financial hardship. So that's important too. Another factor that the courts also consider is the conditions in the country to which you're being deported. If, for example, you're saying you have U.S. citizen kids that are going to face hardship, they may not speak the language of the country to which you are going back to, and that's a factor as well. One of the things that the courts have said is that and there are other hardship factors too. These are the main factors in the hardship that I've seen in the cases. But one important thing is that the courts have said that you can actually combine any kind of hardship that you can find to make an extreme and unusual hardship. So I'll give you an example, which is a recent case that our office just won. We had a gentleman from, I believe it was Ecuador, that was facing deportation, and his wife was on a lot of medications that she could only get in the United States, was getting a lot of therapy, could only get in the United States, and couldn't get treatment back in Ecuador. And the judge granted the case. So for more information about cancellation of removal and other types of distressing deportation, please visit our website at www.immigration-professor.com or call the office of Robert Perkins, 310-384-0200.